Great. I think we can start. Thank you so much for joining this webinar as part of the partnership between Doughty Street Children's Rights Group and Youth Justice Legal Centre. This is our 10th legal guide. Narissa, if we can go to the next slide, that would be great. So 10th in the series of 12. Reporting restrictions for children in criminal cases. This has been a pressing issue for Just for Kids law for many years. They've taken this issue to court for many times and also tried to get involved in legislative changes. This guide is for practitioners in where the law is now. It doesn't mean it's in the best situation, but we hope to offer people a way through what looks like a slightly complicated legal arena. You join us at a very exciting time for YJLC. They are launching their new membership and training program in October 2022. So attendees have an exclusive opportunity to have an early bird special if they want to join and become members of YJLC. You can contact YJLC directly. This is an expansion of YJLC's, I think, well-established program of providing high-quality events, expert guidance, supported by eminent speakers. And it's something that they hope to continue over the next few years. And they look forward to ramping up these expert seminars and trainings and continuing to create a community of like-minded people in the youth justice system. And that's really a very key part of what YJLC's membership and training program is going to be about, really creating that community. So please do join us in the community. We're excited to have you all, and we're looking forward to that. Narissa, if I could have the next slide, please. So, as previously mentioned, we've got a great lineup of speakers today, real leading experts in the landscape of reporting restrictions and anonymity for children in criminal proceedings. We are going to start with Adam Straw, King's Counsel at Doughty Street, thank you so much, Adam, for being involved in editing and reviewing the guide with Rosa, who also is joining us. Adam is a specialist in public law and human rights. He has experience of a wide range of fields, including discrimination, police, prisons, environmental challenges, social welfare, terrorism, children's rights, immigration, crime, and trafficking. He has acted on an important recent public law challenges involving the right to life, abortion, deprivation of citizenship, open justice, inquests, assisted suicide, data protection, pensions, and welfare benefits, and has a range of experience in cases involving restrictions on reporting and open justice. For example, appearing in the leading case on open justice in the inquest context, Crown versus Dyer and versus the coroner, and a leading case about lifelong anonymity for child offenders, RXG. He is the author of the textbook Discrimination in Public Law. Thanks so much, Adam, and we look forward to hearing from you.
Great, thank you very much, Sean. Can you see and hear me? Brilliant. Thanks for that introduction. It's a real pleasure to be speaking with the YJLC today. I know I've only got about 8 to 9 minutes to speak, so I'll get straight on with it. My talk is about the legal framework, so the boring bit. And as a summary, there's either a duty on the courts to grant anonymity to children, in which case you don't need to worry about it too much, or there's a power to do so, in which case you need to be thinking carefully about evidence to show what harm will be caused if your child, the child you're representing, doesn't have anonymity. So that's a basic summary of the whole thing. The detail is, I'm afraid, a bit more complicated. So starting with the pre-charge situation, so when someone's being investigated for a criminal offence, before there's been any charge, the situation is a bit unclear. There's no statutory power or duty which governs what should happen in that situation as yet. But Article 8 of the Human Rights Act helps. You may remember the Cliff Richards case. That was really the most important starting point, which established that if someone is being investigated for a criminal offence before the charging point, then revealing their identity, in other words, saying they are being investigated for a criminal offence, interferes with their right under Article 8. Now, if it's a child involved, that interference is all the greater for various reasons. And what that tends to mean in practice is it will ordinarily be unlawful. It will ordinarily be a breach of Article 8 to publish the fact that a child is being investigated for a criminal offence. Unfortunately, it's a little difficult to protect a child if something has been published about that. Probably the only practical way of doing so is to try and obtain a civil injunction. So to go to a civil court and obtain an injunction against whichever newspaper or other company is publishing the information. Things get a little bit more easy once you get to the charging point. I'll start with the youth court. The automatic position in the youth court, the automatic normal position, is that any child, and that's someone under the age of 18, concerned in the proceedings will have anonymity. And what I mean by anonymity is that no matter shall be included in a publication if it's likely to lead the public to identify that child as concerned in the proceedings. Now, that duty applies to any child concerned in the proceedings, and that means not only the defendant, but also victims or witnesses. The duty for anonymity continues on appeal. So if there's any appeal to the Crown Court or to the High Court under case stated, and it continues until the child is aged 18. There are a couple of exceptions to it. So in particular, for a defendant, after conviction, the court has a power to revoke the anonymity. And it can do so, the statute says, if it's in the public interest. So all of this is in section 49 of the CYPA 1933. And the power to revoke is said within that section to arise if it's in the public interest. As we'll see in a moment, there are quite a lot of different powers to either grant or revoke anonymity. But all of them are phrased in slightly different ways. So some say, for example, the courts may grant anonymity if it's in the public interest to do so. Others, the test is phrased slightly differently. But it all comes down to the same thing. If there's a power to do so, then the court will essentially have to conduct a fact-specific balancing exercise where it looks firstly at one side of the balance, all of the factors that favour anonymity. And this is really critical for you representing a child, because it will be your job to prove that there'll be some harm or some risk of harm if anonymity isn't granted. So the factors that the court can take into account, that there's no limit on them. They're common sense factors, but they can include things, for example, child welfare. They have to take into account child welfare because of section 44 of the 1933 Act, which requires criminal courts to have due regard to the welfare of children. So the starting point is consider child welfare. Is there some adverse impact on child welfare by refusing anonymity, by naming the child in connection with the proceedings? That itself can bring into other factors. Will naming the child have an adverse impact on their rehabilitation, on their education? Will it put them at risk of harm? Will it have an adverse impact on their mental health? So a whole list of harms or risks of harm, but it's really your job, that's the key role that you will have as representing a child, to obtain evidence to show that there will be some harm or risk of harm if anonymity isn't granted. The court then looks at the other side of the balance, what factors, what harm or risks will there be if anonymity isn't granted? And again, it's common sense factors, but the starting point is the risk to open justice. Now, the courts consider that naming a defendant, or at least someone who's been convicted of a criminal offence, is very important. And there's a lot of case law which says that that's a weighty factor. The importance of naming someone who's been convicted of a criminal offence is a weighty factor that they have to take into account. But the court still has to look at that in the circumstances of the particular case. And it may be, for example, if you have a witness or a victim, or the child hasn't yet been convicted, that the importance of naming someone for the purpose of open justice is less. And it will be it'd be important for you to have a look into that in your particular case. So that's the power to revoke anonymity after conviction. I'll move on to the position in the Adult Magistrates Court and in the Crown Court. Children can sometimes appear in the Adult Magistrates Court and Crown Court, for example, if they've been jointly charged with an adult. And in that situation, the automatic anonymity that we see in the Youth Court doesn't apply. But instead, one has to look at Section 45 of the Youth Justice and Criminal Evidence Act 1999, which contains a power to grant anonymity. So you have less protection for your child in the adult courts than in the youth court. In practice, pre-conviction, children tend to get anonymity. Not in every case, but in practice, you have a useful starting point. Again, because there's a power, you have to look at that balancing exercise. There are slightly different legislative provisions involving civil cases. So if there's a civil order, an application for a CBO or an antisocial behaviour injunction, something like that, you have to look at a different statutory power. It's Section 39 of the 1933 Act. But again, it's a power to grant it, and you just go back to that balancing exercise, weighing up the factors for and against anonymity. After 18, the position becomes more complicated. Victims or witnesses can obtain lifelong anonymity. So you can obtain an order from the court saying they will never be named in connection with the proceedings. And that power is in Section 45A of the 1999 Act. Again, it's a balancing exercise. And there are certain gateway criteria within that act that you have to show. So, for example, you have to show that the quality of evidence will be diminished by reason of fear or distress if the witness or victim doesn't have lifelong anonymity. And you also have to look at the balancing exercise. For a defendant, it's more difficult because there's no statutory power. So if you want lifelong anonymity for a defendant in a criminal case, which will normally mean for someone who's been convicted of a criminal offence, then you have to resort to the Human Rights Act. This is sometimes called the Venables jurisdiction after the murderers of Jamie Bolger, where the courts have developed a power to grant lifelong anonymity, even for a convicted child after they become 18. And RXG is an example of a case in which that was granted. But it's very rare, and it's a very high threshold to obtain an injunction like that. You can try to rely on Articles 2 or 3. So Article 2 is the right to life, Article 3 is the prohibition on torture. But the threshold's pretty high. For those, you have to show that there is a real and immediate risk, either of death or of serious injury, if anonymity isn't granted. And that's a very high threshold. So in the RXG case, for example, there were hundreds and hundreds of blog posts following newspaper reports about RXG, containing really visceral and clear threats to kill him. So people saying, if I find him, I will kill him, and describing in great detail how that would be done. And the court just dismissed them. It said, you know, these are vague, they're not going to, they don't meet the threshold by any means. Another article that you can resort to is Article 8. That's much more flexible. You can take into account the kind of factors that I described earlier in the balancing exercise. It's essentially the same test. So look at rehabilitation, harm to mental health, all of those sorts of things. But it's a very high threshold. So the courts in RxG said there has to be a truly exceptional case. There has to be serious harm to the person who's trying to get anonymity. And so you're really up against it. I was asked to mention the United Nations Convention on the Rights of the Child, because that contains in Article 40 the requirement that the child's best interest shall be a primary consideration in all matters concerning the child, including this sort of context. Now, while that may be useful to have in the background, in reality, it doesn't really make much difference in practice, in that there's already a statutory duty on the courts to have regard to child welfare, and that really does the job. The last thing I want to say, I think I've just about reached the end of my 10 minutes. So the last thing I wanted to say was just what to do in practice. If there's a duty, so in the youth court, remember the automatic position, other than a few exceptions, is that there'll be anonymity. So if there's a duty, just check it's been complied with. Just make sure when you first appear in the youth court that the order for anonymity is granted. If there's a power, your job's much more difficult, and you may well be needing to instruct experts and so on, and you'll need to make an application that the power is exercised in favour of anonymity. I hope that covers everything, and I'll hand on to the next speaker.
Thank you so much, Adam. That was really, really helpful. And I just should have mentioned beforehand, if you could please put questions in the Q&A rather than the chat, because we will filter then the questions through to the speakers through the Q&A. But Adam does have to leave a little early, so if you have a specific question for Adam, could you please put it in the Q&A, and we'll try and get it to you, Adam, before you have to leave. But thank you, that was brilliant whistle-stop tour of the legislative landscape and some of the case law. I'm now moving over to Jennifer Twite, who also worked on the guide along with YJLC and Adam and Rosa. Jen is a public law barrister specialising in children's rights and is my co-author of Youth Justice Law and Practice. She was the head of strategic litigation at Just for Kids Law and represented one of the girls who was convicted of murdering Angela Wrightson at the age of 13. When Jen was representing her, it was in her case before the High Court, where the High Court granted her lifelong anonymity to both the girls that were involved in that murder when they were turning 18. Before that, Jen practiced as a criminal barrister for many years, specialising in defending children, and dealt with many applications before the Crown Court for reporting restrictions in relation to child dependents. At Just for Kids Law, she was involved in campaigning and policy work around the issue of anonymity, which included work with the press regulators, giving advice to local authorities, and an intervention in the Court of Appeal in Northern Ireland about the failure of the Department of Justice there to prevent the press from publishing the details of a 15-year-old boy who had been arrested but was not charged with fraud. Through all of her experience, which as you can hear is quite vast, Jen is going to help all of the rest of us practitioners think about practical issues that can arise in the legal landscape and how we can prepare for them and hopefully overcome any barriers that might arise. Thanks, Jen. Look forward to hearing from you.
Thanks, Shauneen, and thanks for Adam for setting out the initial legislation and how it all works. As Shauneen said, I want to, in my 10 minutes, just talk about some practicalities about how applying for reporting restrictions works in the criminal courts. And in particular, I'm going to look at some of the major pitfalls and the need to be prepared for them. Secondly, some arguments that often come up, especially in the Crown Court. And thirdly, I'm going to very briefly touch on appeals. Firstly, pitfalls and the need to be prepared. It does seem a little bit odd to talk to a group of people who've chosen to spend time coming to a talk on anonymity about the need to be prepared, because I feel like you're not my target audience. I'm sure people who are going to spend an hour listening to us are going to be really prepared for what will come up in the criminal courts, whether it be youth court, magistrates or Crown Court. However, it is worth flagging a few issues that often do get missed. As you've heard from Adam's very full explanation, you get automatic reporting restrictions in the youth court. Worth looking out for, of course, those reporting restrictions only kick in once the child is charged with an offence. So pre-charge, there aren't any protections. We see that less and less being a problem, partly because of the case law that Adam just spoke about, really clarifying that it is a breach of Article 8 to name people pre-charge, but we have seen instances of it happen, so it is worth pointing that out. The other thing that often gets missed is that those reporting restrictions under Section 49 of the Justice and Criminal Evidence Act only kick in when you're charged with a criminal offence. So children in front of the youth court, even if it's in a youth court, but therefore a civil injunction, so in particular things like antisocial behaviour injunctions, but we're now seeing gang injunctions, and there are a lot more civil injunctions being used more and more. Though in those cases, again, there aren't automatic reporting restrictions. So they come under what Adam pointed out, is that there's a power to have reporting restrictions. There's no automatic reporting restrictions. So in those cases, you need to apply for them. And finally, of course, as Adam pointed out, there's no automatic reporting restrictions if you're sent to the Crown Court, or if a child appears before an adult magistrates court. And again, that's something that often gets missed, because if children appear before an adult magistrates court because they're jointly charged with an adult for their first appearance, or maybe no youth court sitting that day, I think a lot of people miss the fact that then reporting restrictions don't automatically apply, and you do need to make an application, which should be under Section 45 of the Justice and Criminal Evidence Act. So that's just a quick reminder to double check, if you're ever representing a child, that you've double checked that there are reporting restrictions in place. They might not always be automatic when you think they are, and therefore applications may need to be made. Whilst you may need to make an application, it is very unusual for a child not to get reporting restrictions during the trial itself. That's set out in Aylesbury Crown Court and is very clearly set out in our guide. In fact, I've never heard of a case, I'm happy to be corrected, where a child's been named during the trial proceedings. The time when you usually have the argument about whether or not a child should be named in the press, it is on sentence at the end of the proceedings. And so finally, the last issue I wanted to raise about sentence is to be prepared for it to happen. I've been involved in a number of cases where we all thought that reporting restrictions were in place and were set to continue, and then almost without any warning, at the sentencing hearing, the judge says, well, wait a minute, why should reporting restrictions continue? I think I might lift them. And I've seen that happen even without an application from the press. And so thinking about it, not assuming that just because you've got reporting restrictions for the trial, thinking about what evidence you might need, making sure that any application is made based on evidence, as Adam stressed as well, I think is really important. We've got a whole section in the guide on page 22 about the sort of evidence that you can obtain. And obviously it's going to vary from case to case about what's realistic and what you can get, but I remember thinking about this when we went to the High Court representing Dee, who got anonymity. And in those cases, you have files of evidence. You have reports from experts, you have witness statements from loads of people who can give relevant evidence about the issue. You are unlikely to get that level of evidence, I accept, in a Crown Court application, but they're often the same children and it's often the same decision being made. And I've had to sometimes make applications based on 10 minutes worth of instructions and no evidence in the Crown Court for these matters. And it does feel a kind of weird juxtaposition that you have in some of these hearings, huge amounts of evidence about whether or not a child should be named, and in other hearings, I say just 10 minutes worth of instructions. So I did want to emphasize the importance and the usefulness of getting proper evidence, whether that be even from the youth offending team. I know we're going to hear from someone later from the youth offending team, or more specialist experts about what the impact on that individual child will be, should they be named. And that really brings me to my second point, which I wanted just to flag, is the sort of arguments that do come up when you're in that position, normally at a sentencing hearing, deciding whether or not a child should be named or whether reporting restrictions should continue in the Crown Court. And really, despite our lengthy guide on it, this isn't a legally complex area, I don't think. These cases are very, very fact specific. And I think are much more effective when they're very individualized and fact specific. In fact, I don't think it's that much different from criminal practitioners who will be aware of sentencing exercises. There's a lot of case law around. There's a lot of case law looking at different individual situations and deciding whether for that child they should or should not be named, just like there's lots of case law in sentencing. But if you go in front of a Crown Court judge with 10 cases on sentencing, you know, they will tell you each case turns on its own facts. And it's the same with anonymity. The leading cases, there's a particular leading case of Aylesbury that's cited in our guide, along with a more recent case of KL in the Court of Appeal last year. It explains the balancing exercise and gives a list of factors that need to be taken into account. But essentially, it is balancing that press interest, the right of the press to be able to report or open justice against the harm done to the child. And how that balancing exercise plays out will just vary from case to case and will just be different depending on what's going on with the child you're representing. And whilst there were a lot of very similar arguments, and I'm going to look at a couple in a moment, that we made in each case, the more individualized you can make it in your particular case, I think the more effective your argument will be. Just like if you go to court and sort of give generic arguments about why prison is bad, that's not necessarily the most effective way to get your client to suspend a sentence. You make it particular to your client. It may well be that you make the same arguments almost in every single case, and I think the same is true here. There are a lot of arguments, rehabilitation, for example, that will be made in most cases, but you have to bring it back down, I think, to why the rehabilitation of this particular defendant is contingent on them having their identity protected. Having said that, obviously a lot of the case law and some of the case law we've put in the guide isn't necessarily binding authority, but is quite interesting because it gives you, well, for me, I find it useful to see what arguments the Court of Appeal or other courts have used, because I can steal them from my argument or my case. But they're not necessarily always sort of binding authority that you would necessarily rely on, but it gives you perhaps more ideas or good ideas about how to argue it in different circumstances. So I wanted to look at a couple of arguments that often come up in these cases, because I thought that would be useful. If you look at the guide, we go through the sort of arguments that often come up. So for example, the need for the child to be rehabilitated, I think, is a really key one, and how naming that child will impact on their rehabilitation. Adam talked also about things like Article 8, and that's where rehabilitation obviously would come under, but also you have specific harms that someone might face if they're named, whether it's retribution, whether it's their mental or physical health that might be harmed. And so there might be in different cases, different arguments that you can make about the harm to the individual should they be named in the press. But I want to look at in particular the relevance of the seriousness of the offence and also turning 18. So it's quite clear from the case law, and actually by the way the statute's laid out, that there's a deliberate policy to make it more likely that you are named in the press if you've committed a more serious offence. And as I say, that's listed in some of the cases as a relevant factor. A more serious offence is more likely to lead you to be named. And also we know that in the youth court, you get automatic reporting restrictions, whereas you don't in the Crown Court, where you usually go, where a child normally goes, they've committed a more serious offence. And whilst if you get automatic reporting restrictions in the youth court, those can be lifted at sentence. It's quite clear, both from the statute by the reading of section 49 and by case law such as McCarry, that you are less likely to have your reporting restrictions lifted in the youth court than you are if you are sentenced in the Crown Court. So both from that and from this case law, it's quite clear that the seriousness of the offence is quite relevant. And most of the cases where we see children are named, it is for very serious offences. However, what do you do then if you've got a child charged with a really serious offence? So a couple of points I wanted to make. Firstly, we also see an awful lot of serious offences where children aren't named. Adam's case was a great example. RXG, at the time, the youngest ever convicted terrorist in the UK. We've seen a number of children convicted of murder who've managed to retain their anonymity, both at trial and in some cases for life under Section 6 of the Human Rights Act. What's interesting, I think, in these cases is the focus on rehabilitation. There are a couple of interesting cases, both named in our guide, that talk about how a lengthy criminal history or a bad criminal history might actually be used as a factor in favour of keeping anonymity, because for those children, the need to rehabilitate them is arguably even more important, and there's an even greater public interest in them being rehabilitated than someone with a less serious criminal record. So you do see cases where the courts have almost turned that on its head and said, the fact it's a serious offence means it's even more important to rehabilitate them. And if we need to keep them anonymous to do that, then that's where the public interest lies. It's also worth, and sorry, what I also want to say about that is essentially that's not dissimilar to the argument made in the RXG case, where there was a lot of concern about the fact that he would be used as a poster boy for Al-Qaeda, and that rehabilitation was really looked at as the key to why someone committed such a serious offence should retain their anonymity. And I've seen it in similar cases where people are trying to get out of gangs, for example, where we've used that as an argument to say their ability to reintegrate themselves into society and escape the gang is contingent on them remaining anonymous and not having their names and their details printed in the press. So I do think that you need to not, even when you've got a serious offence, look at ways you can get around that, to think about whether or not there are good arguments for retaining the child's anonymity. And the second thing I wanted to talk about was turning 18. And the reason I'm concerned about this is there's been a number of arguments I've seen in cases. If you look at the judgment of DNF, the two girls, one of whom I represented, when they were given anonymity at the end of the trial initially, one of the arguments the judge put forward as a favour of not giving them anonymity was the fact that they would lose it when they turned 18. And that again was used, I think, in the Will Cornick case. It's been used in a number of judgments where the judges have balanced, favours in favour of reporting restrictions and factors against. And I said one of the reasons we should not give reporting restrictions is that they're going to lose that anonymity anyway, and they'll be named anyway when they turn 18, and that's only a year away or 6 months away or 18 months away, whatever it is. So what's the point? And that concerns me because I think it's an entirely wrong analysis for a number of reasons. Firstly, there's quite a lot of helpful case law. Well, there's a couple of helpful cases talking about the need to be anonymous whilst you're still rehabilitating and while you're still a child. There's a great phrase called, I think it's in Aylesbury, the case of Aylesbury, where they talk about the need to be anonymous before the child has the burden or benefit of adulthood. And so the idea that you're still growing up, it is still a useful thing to do to protect you whilst you're still while you're still younger from that press intrusion, and that might be an important part of your rehabilitation that might be hindered by being named. And so it's not right just to say what's going to happen anyway, we might as well do it now. Secondly, of course, it's not true that they will definitely lose their anonymity when they turn 18. I find it's the reason I pointed out that it was used as a factor in the case of DNF was that those two girls went on to get lifelong anonymity in the High Court. And while that doesn't happen very often, it's a very handful of cases where it happens, it's not inevitable that these children will lose anonymity when they turn 18. So I think it's a very dangerous thing to assume that will definitely happen. And thirdly, if anything, I think it should be a factor on the other hand, because when you're looking at balancing the rights of the press versus the rights of the child, or the welfare of the child, the press obviously are only being prohibited from reporting the identity of the defendant for the 6 months, 18 months, whatever it is. And so actually, in some ways, that should be an easier argument to make in the Crown Court, to say, actually, you're only making a decision for the next 2 years, 18 months. And then the matter could be revisited perhaps when the child turns 18, or probably won't be, they'll probably just be named. And therefore, surely that's less of a burden on the press to be able to restrict them in that way. There are a number of other, obviously, factors that get put up in the mix, which I don't have time to discuss, but those were two that I really wanted to look at. But the factors are all listed in the guide that we think are relevant. And as I say, we can't emphasize enough that the factors in each individual case will vary from case to case. I feel like I've probably spoken for my 10 minutes, but I hope that's useful.
Thanks, Jen. That was really, really helpful. And I'm sure we'll come back to some of those issues in the Q&A. It's now my great pleasure to hand over to Dr. Louise Bowers. Louise is a registered forensic psychologist and a chartered psychologist. She has over 30 years of experience working as a forensic psychologist in a range of settings, including the prison service, the youth justice service, the parole board, the NHS, and private providers of secure and non-secure forensic services. She has been a director of the Forensic Psychological Service since 2005 and splits her time between practice, assessment and treatment, and being an expert witness, providing group and individual supervision, and working for her professional body. Louise lectures at a number of universities and holds an academic position at Cardiff Metropolitan University. She specialises in the assessment and treatment of young people who have been accused of or have been convicted of serious offences, and this is her primary area of research and practice. Louise has special expertise in assessing the psychological impact of publicly identifying children who've been convicted of offences, and is often asked to give opinions about this at sentencing. Of the 8 children who have been given lifelong anonymity orders once they were turning 18, Louise was appointed as the psychological expert in 4 of those cases. So it's a real privilege for us to have you here, Louise. You obviously have been involved in half of the cases of lifelong anonymity for 18-year-olds. And so we really appreciate learning from your expert view on the issues that can be included perhaps for yacht workers in PSR, and also in expert evidence when thinking about the psychological impact on children being named. Thanks so much, Louise, over to you.
Lovely. Hopefully you can all hear me. I'm sure somebody will tell me if you can't. I'm just going to share my slides. And again, unless somebody tells me otherwise, I'll assume they've come up. Okay. Right, nobody's telling me otherwise, I assume they come up today. Thank you so much for inviting me to come along today. As Shawnee's just said, I've worked on 4 of the 8 cases where children have been given lifelong anonymity. And it's been an absolute honour and a privilege to be involved in their lives, and also to work with such talented legal teams who are willing to take these cases forward. So today what I wanted to talk to you about was the role of the expert witness in these sorts of cases, and also having an overview of that, what I've learned so far from the 4 cases I've been involved in. So first of all, I want to talk to you about the cases, and then some of the similarities and the differences between them, and then going on briefly to tell you about the sorts of things expert psychologists can do that might support you, and then a little bit about the lessons I've learned from being involved in these cases. So first of all, the actual cases. So there's one adult who's been given lifelong anonymity criminal case, and that's Maxine Carr. Not going to say too much about her. You'll recall she was the partner of Ian Huntley, who killed Holly Wells and Jessica Chapman in 2002. She was an adult, so I would never have had any involvement in her case, but she was granted lifelong anonymity at the point of release. And then the 8 children who've been granted lifelong anonymity. The first one was Mary Bell. Again, for obvious reasons, I had no involvement in the Mary Bell case. She was convicted in 1968 and was granted lifelong anonymity in 1980 when I was still at school. So absolutely no involvement in her case. And that was extended in 2003 and 2009 to include protection for her daughter and then subsequently her granddaughter. The next 2 cases who were granted lifelong anonymity are Robert Thompson and John Venables, who everybody will know were the 2 10-year-olds who were convicted of killing the toddler James Bulger in 1993. I wasn't actually a psychologist when they were convicted, but I was by the time they were applying for release. And I was actually a member of the parole board at the time and was involved in their decision to release them. But for obvious reasons wasn't involved, if there were indeed any experts involved, in the actual application for lifelong anonymity. The next 2 cases, and I was involved in both of these, are Child A and Child B. These are 2 brothers who were aged 10 and 12 at the time, who were convicted of very, very serious physical and sexual offences on 3 young male children. These offences took place in Edlington in Doncaster, and colloquially this is known as the Edlington case. They were given detention for public protection in 2010, and I was involved in their application for lifelong anonymity, which was granted in 2016. And I'll be talking a little bit more about their case as we go through. The next case who was granted lifelong anonymity was RXG, who you've heard quite a lot about already this afternoon. He was given a life sentence when he was 14 for inciting terrorism overseas. And at the time, he was the youngest terrorist in Britain. And he had a plot and got very close to actually blowing up the Anzac Parade in Melbourne in Australia. His identity was protected at trial. And he was given lifelong anonymity in 2019. I should actually have said Child A and Child B were also given their identities were protected at trial. And then finally, the most recent children to get lifelong anonymity are Child D and Child F. I worked alongside very closely with Jen on the case of Child D. And obviously Jen's talked quite a lot about this case already. These were the 2 girls. Child D was aged 13 at the time, Child F was aged 14, and they basically tortured and murdered a woman in Hartlepool, Angela Wrightson. Again, their identities were protected at trial, but interestingly, there was so much media intrusion and media interest in their case, and some of the issues that were raised on social media were so serious that their first trial was actually halted, and they were granted a retrial with some very strict reporting procedures in place. It became to pass they weren't actually probably going to be able to have a fair trial, and the trial was halted and started again. I wasn't involved at that time in 2015, but I imagine to great detriment to their mental health and well-being, the fact that the whole trial had to start again, and they were granted lifelong anonymity last year. Okay, so my views on the similarities and differences between these cases. If we start with the similarities, all of the children I worked with, and I believe the other children as well, came from extremely challenging backgrounds. But interestingly, I would say, having oversight of these cases, the similarities end there. In terms of differences, they are vast. So some of the children I worked with had diagnosable conditions, but some didn't. The children I worked with, they were all placed in different cases. So some of the children were in secure children's homes, some had already been transferred to an adult prison, and some of them were actually living quite successfully in the community at the point I became involved. There was differences in the degree of identification of the child at the point I came to assess them. So some of the children had managed to fly under the radar, and it wasn't particularly well known what they were in for, and other children, it was quite openly talked about within their placement about what they were in for. Some of the children had already adopted a new identity at the time I assessed them, and others had kept their birth name. The levels of engagement with rehabilitation, again, was quite vast. Some of the children I worked with had engaged in extensive rehabilitation and were fundamentally different to the child who'd entered prison. And particularly in one case, which I'll talk a little bit about in a moment, she had only just started to engage in her rehabilitation journey when I was assessing her. There was big differences in the levels of risk in terms of the risk they posed themselves, but also the risk they posed to others. The degree of public interest and hostility and threat, again, I'll come on to talk about that a little bit later on, but again, that was quite different amongst the children I assessed. And in one particular case, one of the children I assessed, again, this is in the public domain, didn't actually have the capacity to engage in litigation and had a litigation friend to support him, but the other children were actually able to engage with their legal team in terms of making their own application for lifelong anonymity. So you can see there's broad differences there. And again, the take-home message is there's no typical or obvious case. Okay, so the role of psychology in all of this. How can we help you? So there's a general assessment. So I would typically assess the risk the young person poses of reoffending generally. I would think about the risk of harm they might cause if they did reoffend. I'd be thinking about their strengths and their protective factors. I'd be assessing their needs more generally, so going beyond their offending behaviour needs and thinking more generally about their mental health, their well-being, neurodevelopmental conditions, learning difficulties, disabilities, and those sorts of issues that would be relevant to their progression and rehabilitation. I'd be thinking a lot and assessing the extent to which they'd engaged with efforts to address their needs, and then thinking more specifically about the impact of disclosing their identity. So it's thinking about the impact of disclosing their identity on various aspects. So thinking about how identity disclosure might impact on their psychological presentation and functioning. I'd be thinking about how disclosure of identity might impact on their psychosocial maturity. There's a lot of important work going on at the moment about children's maturity and how being in secure conditions can delay their development of psychosocial maturity. And I would be assessing how disclosing their identity at that point could actually hinder their development of maturity. The big one is assessing the impact of disclosing their identity on their rehabilitation. And that is always a big feature of any assessment I would do. Within that, I'm often asked to assess the impact that the child being linked to their offences would have on their ability to access suitable accommodation, thinking about would they be able to access education, would they be able to access training, what is it likely to be like for them if they're linked with their offences they committed as a child, what are their realistically likely employment opportunities likely to be. Also, a big one is their capacity to form and maintain relationships. And I'm thinking about friendships as well as intimate relationships. Think of these children's identity being exposed and they are forming friends, or they're developing intimate relationships. And the first thing those people do is, Google their name because they know they've been in prison, and all this stuff about what they did as a child comes up. You'd then be thinking about, what is the likely impact on them being able to form friendships and form intimate relationships moving forward. And then the big one is, if their identity is disclosed, in some cases, that might actually increase the risk of them reoffending. And I think we demonstrated that quite comprehensively in our XG. If he was linked to his offences, and as Adam's spoken about, he became the poster boy for Al-Qaeda, what would that mean for potential re-radicalisation? Okay, So what have I learned as a psychologist involved in these cases? Okay, the first major thing I learned, which I wasn't aware of until I became involved, was I was asked to review the online, it is typically online, hostility and abuse that's publicly out there. Thinking about child A and B, they were colloquially referred to as devil boys, hell boys, torture bruvs. And at the point it became known that they were making an application for lifelong anonymity, this is something was in the press, that the freed monster boys who tortured children are seeking lifelong anonymity. The brothers who battered, strangled and sexually abused two friends apply to remain unidentified as adults. And you can only begin to imagine the sorts of comments that public made when they became aware that Child A and Child B had made an application for lifelong anonymity, and I had to wade through all of this and take a view about the impact that might have on Child A and Child B if they became aware of that. Okay, this is a comment that was made in relation to RxG. There was hundreds. I mean, there was just a file full, but these are some of the ones that stayed with me. That he should be publicly hanged with his remains being fed to the pigs. Another one, release him to me. His identity will remain secret for life. I promise never to tell anyone where I buried the fucker. This is a child. Can you imagine, reading that about yourself, that this is what members of the public would like to do to you? And then in the case of Child D and Child F, they became colloquially known as the Snapchat killers. There was a film made about them that was released around the time they were applying for lifelong anonymity. And again, these are sorts of things that were said about them when it became known that they were applying for lifelong anonymity. They both want hanging. God, they make me feel so fucking angry. Evil witches. They want skimming and leaving to rot. Put them to sleep. They won't reoffend. And again, these are comments about children who are trying to rehabilitate themselves. I think that sort of abuse speaks for itself, and it was quite distressing for me as a practitioner to have to wade through this and think about the impact on these children if they had to live their lives when this was publicly being said about them. Okay, the second thing I've learned is that each case is totally unique, and I think Jen's already highlighted this. If you ask an expert to get involved, it's really important that they focus specifically on the child that they've been asked to assess, not the work that's gone before, and make it unique to that child. And in my situation, each child was absolutely unique. So in the case of Child A and Child B, when I assessed them, they were both successfully living in the community. I assessed them as low risk, but I assessed there was a high level of threat from members of the public towards them. And lifelong anonymity was granted on the basis of that immediate threat to their physical safety and the impact on their continued rehabilitation and development if their identities were made public. They'd done incredibly well in their rehabilitation, and it was assessed that part of my evidence was that that would be damaged, probably irreparable. I can't say it. There would be no repair to that damage if their identities were disclosed. In terms of RxG, he was living in a secure children's home when I assessed him. He was still moderate risk of reoffending. He'd actually been diagnosed with a neurodevelopmental condition. He had autism. Again, that's in the public domain. And interesting, in his case, all these awful things that were said about him, the decision was made that those were not real and credible threats to him. And so lifelong anonymity for him was not granted on the basis that he was at immediate risk of harm, but it was about his ongoing rehabilitation. And I talked extensively about the harm that would be done to him and the chances of him being able to, in the short-term future, successfully reintegrate into the community if he was forever linked to terrorism offences and held up as Britain's youngest terrorist. In terms of Child D, again, the situation was different again. Because of the COVID, the pandemic, I assessed her, first of all, in a secure training centre, and then by the time I had to reassess her, she'd had to be transferred to a women's prison because of the time lag, because of the COVID pandemic. She'd only just started to engage in interventions, and she was doing much better in an adult prison, having been transferred anonymously. because she'd only just started to engage in intervention. She was still a high risk of offending at that stage. She had a diagnosed mental disorder, and the risk to herself was high. She engaged in acts of self-harm, and she really was a genuine risk that if she was identified, that the risk would ramp up and she could, make a serious risk to take her own life. Again, there was the judge assessed there was no credible physical threat to her, despite what was being said online about her, and also Child F. That was not demonstrated. But the lifelong anonymity was granted on the basis of the risk to herself and the associated impact on her longer term rehabilitation if she was exposed in an adult female prison as the person who had murdered Angela Wrightson. So again, completely unique, and each case that you have to make the argument for that specific child and their specific needs. And finally, I have no idea how I'm doing for time, but I've reached the conclusion that psychological evidence genuinely supports legal argument. I fly under the radar. My daughter always describes me as the most famous forensic psychologist you've never heard of. I don't court media, I don't do interviews. And so at great pains to myself, it was really hard for me to demonstrate that psychological evidence can support your legal argument without actually having to refer to my own work, which I find just acutely embarrassing. And so what I tried to do is just take a quote from each of my reports, which I'm not going to read out, you can read it for yourself, that demonstrates how psychological evidence supported legal argument. And I'm literally going to lead those up there because I'm acutely embarrassed about the things that are said there. You can just read those for yourself. So I think that's everything from me. I'll be more than happy to answer any questions that come up later. Obviously, I'll only be able to talk about the type of information that's in the public domain in terms of judgments anyway, but I'm more than happy to answer questions about supporting children to make applications for lifelong anonymity. Thank you.
Thanks so much, Louise. That's really, really helpful. I'm sure there'll be lots of questions that we'll come to after we've heard from Mike. So the idea of these webinars is that they are kind of multi-professional insights into these particular areas of law. And we're really grateful that Mike has agreed to speak with you today. Mike Blower is the service manager of Targeted Youth Support Service for Wigan Council and has worked in youth justice since 2006, started in Surrey, where he began as a practitioner before eventually becoming the head of the yacht there. After leaving Surrey in 2019, he's worked in youth justice senior leadership roles in Bradford, Bury and Rochdale, and now at Wigan Council, where he is a service manager for the Targeted Youth Support Service, an integrated adolescent service incorporating youth justice. He is also the Greater Manchester Youth Justice Lead for Health, Transition and MAPA. Mike is passionate about delivering a preventative child-first youth justice system in Wigan and across Greater Manchester, and working with partners to ensure that children worked with are supported to express their voice, access the support they need and reach their full potential. Which is a great starting point. Mike, thank you. Can you help us a little for youth justice practitioners who might not be lawyers to think of how they can integrate the child first approach into their work, particularly around this issue of anonymity? And we were also kind of interested in the responsibility of the youth offending team or the youth justice services in continued consideration of this issue during and after the conclusion of legal proceedings. So I will hand over to you, Mike, and thank you so much for speaking.
Thank you for the invite. Great to see so many people online at the webinar, and also great to see colleagues from previous areas that I've worked online as well, from Surrey, who will know far more about this in practice than I do. But I'll give it a go in terms of putting this in a youth offending team practice context. If we can move through a few of the slides, keep going, because I think we've covered the legal framework. So I suppose I'm gonna speak about speak about anonymity through through the lens of child first youth justice, because I think it aligns really well. So child first youth justice is a kind of accepted approach now for youth offending teams, in terms of the starting point for addressing youth offending is to start with consideration of the child as a child rather than as an offender, and that's encapsulated in the Youth Justice Board's strategic Youth Justice Board for England and Wales strategic plan, and also now all youth offending teams have to outline in their own youth justice plans how they are adapting child first principles in practice in their local teams. So some of the core principles that align with the kind of need for anonymity is it's clearly really important to recognise that children are different to adults in terms of their development, in terms of their maturity, in terms of the adolescent brain in relation to sort of risk taking and impulsivity, and that's why it's so important that children are treated differently from adults in the criminal justice system. And that's why in relation to anonymity, it's crucial that children are treated as children in that regard, and their anonymity is protected as far as possible. I think the other key principle really in terms of child first and then thinking in relation to anonymity is that children committing crime is accepted as a kind of reflection in our society and a problem for all. And in that sense, it kind of responsibilizes adults for children's behavior. It doesn't just blame children or hold children fully responsible for their behavior. It's a reflection of a wider society responsibility, which puts the onus on adults to actually take some responsibility for how this is addressed. And that is a key element in terms of then feeding into anonymity, in terms of the responsibilities of adults to protect children from being sort of named and shamed and identified. I think sometimes within a sort of legal framework, it's easy to sort of think as distinct groups of defendants and distinct groups of victims. But in terms of children that we work with in youth justice, they're often the same children. So there are many children who are defendants in court who have also been victims of crime, or more broadly or more widely, they've been victims of exploitation and victims of other types of abuse and trauma in their lives. So it's important that we don't kind of frame and separate children who offend and children who are victims, because then they are two sides of the same coin. We've heard a lot from Louise about how the kind of psychological and developmental impact on children where anonymity is breached. So anonymity recognises an important facet of child first, that child's development and child's well-being is developing all the time through childhood, and to kind of publicly name them and dismiss their anonymity is going to have a significant impact on their development and their well-being. We also know that anonymity promotes rehabilitation. So if you are to be named and shamed in a public arena, then that's clearly going to have an impact on kind of stigma and how you identify as a child, in terms of how you feel about yourself and how that may then impact on your behaviour. There's also safety issues in terms of anonymity, in terms of threats to the children from the public, and some of that we've heard in some of the examples in the last presentation. And obviously recognising the stigma on future prospects, so education, training, employment and future life prospects that can be significantly damaged. And then it's been touched upon in a couple of the other presentations as well, but Child First also really needs to start at pre-charge anonymity. So there's quite a lot of protections and safeguards in relation to it being applied upon charge and through court proceedings, but actually there's a loophole in terms of the possibility of that anonymity being breached pre-charge. So what can, if we move on to the next slide, what can what can youth justice workers or youth justice teams do in working together in partnership with legal colleagues to try and ensure that this is a kind of area that courts are aware of and children are protected as much as possible. Well, I mean, one of the things I think practically that we can do is to actually recognise the impact of loss of anonymity in pre-sentence reports, especially for the Crown Court where there's more risk. So, you know, I think within an actual pre-sentence report, it's worth naming the risks of anonymity being lost, and that being sort of, you know, upfront within a pre-sentence report, so the court have clear information about how that could impact. I think it's really important for legal professionals and youth justice and children's social care professionals to work as closely as possible and have early conversations in court proceedings where this might be a risk, and particularly in relation to looked after children who are kind of additionally vulnerable. So those kind of early conversations between key professionals and that partnership work is important. When I was talking to colleagues across Greater Manchester about preparing for today, one of the things that came up really was that in a sense the core issues and the reporting restrictions are actually the easy side of this in relation to children remaining anonymous. The wider risk and where we've seen children exposed more readily is via breaches via social media, and the potential impact for children to become known through kind of Facebook, social media accounts locally, which have a real impact on those individual children in their local community. And I think social media users may be generally less aware of the law and restrictions and the risks posed by sharing comments. And just as an example of that, I mean, in Wigan in May this year, there was a headline that said Wigan teen menace admits to violent crime spree. A 16-year-old tearaway has admitted to committing a catalogue of crimes in Wigan. The teen who cannot be identified, it says, but then it goes on to kind of name the victims and goes into quite a lot of detail about dates and offences committed. And the upshot of that is that it's pretty easy then to identify who that young person is on social media through kind of local Facebook pages, even though their name hasn't been reported publicly or in the press. And then finally, I think another sort of tip to remember, and again this has been touched upon by colleagues earlier, is that it's really important to remember in court to seek anonymity and restrict reporting in relation to criminal behaviour orders or other antisocial behaviour injunctions, and remember that that's a sort of additional safeguard that's needed. So, you know, occasionally we've had situations across Greater Manchester where children have been publicly named in relation to antisocial behaviour orders, even though perhaps their court case wasn't reported on in terms of them being named. That actual antisocial behaviour order has been promoted publicly. So it's just an additional thing to remember in court. And that's it from me.
Thanks so much, Mike. Sorry, just trying to turn on my video. We really appreciate it, and I think it's really helpful to think of it from all of those different angles. We're just going to go to the Q&A, but I wanted to also thank Rosa Paleschek, who is also going to join the panel for Q&A, who has been very much involved in the anonymity guide. Rosa is an experienced public law practitioner from New Zealand who is currently completing her pupillage at Doughty Street Chambers. She worked with Adam Straw KC to edit the anonymity guide and has assisted members of Chambers with advice on other issues at the intersection of public law and youth justice. So if I could ask the speakers to turn your cameras on, and then we can go through some of the questions. We've got 20 minutes for questions. Thanks, great to see you all. So the first question really is for all of you, and I'm not sure that there's a right answer, but I'm interested to know what your views are on it. Whose responsibility do you think it is to realise that a child who's been granted anonymity in their criminal proceedings is turning 18, and that there might be a need to consider an application to the High Court? Who should be alert to this issue, and then who should they refer it to? Mike, I'm going to start with you, if that's okay, because you're at the top of my screen.
I suppose it doesn't necessarily need to fall to one individual agency or person to do that, but I mean, clearly in youth justice, we will be working sometimes with children that are transitioning to 18, transitioning to probation, or remaining with the youth justice service shortly after their 18th birthday. So certainly in terms of a youth justice perspective, that's something that, you know, we can be aware of as a professional working with that young person. But it probably takes a bit of a partnership approach in order to actually then, you know, ensure that that's addressed through representation.
Do you think is there something on youth justice systems that alerts people to when a client they've been supporting is turning 18, and that their losing their anonymity might be an issue?
No, I mean, but obviously we'd certainly be aware of when a young person was turning 18, but it's making me think in particular actually around where we transition young people from youth justice to probation services. It actually, as part of that transition practice, that could be part of our sort of checklist with probation, and make it a more explicit consideration.
Yeah, that sounds great. Jen, sorry, if I lawyer's point of view, do you think that also should lie with the trial lawyer, and is it often the trial lawyers that would try and take those injunctions?
I think it does lie with a trial lawyer. I mean, so I definitely think that if you've managed to get anonymity at sentence, you should be on an obligation to explain to your client the effect of that, just like you're on the obligation to explain to your client the effect of any sentence or any order that this expires at 18, and they might want to do something about it if applicable. I haven't seen trial lawyers take those injunctions that Louise was talking about, because as we've heard, there've been about 8 of them, and so they're very specialist, and so they tend to be taken by specialist lawyers. I suppose my advice is for trial lawyers to make sure that you explain to your client what will happen when they turn 18, and refer them to someone who does that work if that's relevant and if it's applicable. Because
we can't expect the child to remember that, right?
No, and all the children, and I've actually dealt with, not just Deep, I've dealt with a couple of people who's affected, and none of them had any idea. And I'm not saying that actually means the trial lawyer didn't explain it to them, because of course we know that when you're 14 and you're being sentenced, for example, for murder, you've got an awful lot of information, you're not necessarily taking it all in. And I think there's probably a wider discussion about how you impart information to people in those circumstances. But no, I don't think, you know, you're not talking about people who are really able to take everything in and know what's happening. So I do think that, I think everyone, the answer really to the question is everyone. It should be, the trial lawyers should be doing something, social services have duties, if this child's in custody, they're definitely under the care of the local authority, and maybe otherwise. So I think there's going to be a number of professionals involved in a child's life, and I really think they should all be looking at it and referring them to a lawyer where it's appropriate.
Great, thanks, Jen. And Louise, just from your perspective, obviously you've been involved in cases both at the injunction level, but then also at the sentencing hearings, and where you are instructed presumably by the trial lawyer, or has it been social services that's brought you in at the sentencing stage?
For the 4 cases I've talked about this afternoon, I was only involved
those are the injunction.
The injunction stage, but I have been involved because I work a lot in the Crown Court with children, where just as part of my instructions, when there's been a finding of guilt or the child's decided to plead guilty and it's a very serious offence, sometimes the instructing solicitor will ask me to address the impact on them of, they're going to be sentenced, what will happen if we withdraw their anonymity at this stage. I'm often asked to comment on that. that would just be part of my assessment of them anyway.
So you don't come in particularly on an anonymity point at sentencing. It's always been a part of your general assessment.
Yeah, I've never been asked to specifically come in just for that, but I think because I typically would be working with children who've committed very, very serious offences and are facing an extended or determinate sentence, it's just part of that. Yeah, no, I've never been brought in specifically at the sentencing stage to address that. And
just in your experience, Louise, is it are they different kinds of lawyers that you work with in the High Court in that public law context and the trial setting?
Totally. Yeah.
Rosa,
apart from working the Crown Court, at the sense that the child will often just stick with the lawyer that was on duty when they often just stick with them, or they might change. But when you get to the injunction stage, in all the cases I've worked with, it's been very, very specialist children's legal teams that I've worked with.
Great, thank you. Rosa, do you have anything you would like to add into that?
No, and sadly, this is when you're all missing having Adam jump offline, because I think it's fair to say, as Jen pointed out, that they have all been specialists, like Adam and Ed Fitzgerald QC, who have taken a lot of those cases. Just the only other thing that I'd add in respect of your initial question about who should be involved in looking out for these type of issues when a child is turning 18, as well as when a child is turning 18, it's also worth noting, and there might not be very many prosecutors on this call, but there are duties on the CPS as well to look out for reporting restriction requirements. And we've referenced that in the guide. We've made a number of references to the duties that fall onto prosecutors as well. And there are also examples, of course, where local authorities have gotten involved in various proceedings. So I think it's completely right of Mike and Jen to say it's trial lawyers, it's social workers, but actually that duty is really broad, and everybody who's involved should be looking out for their role as well.
Thanks, Rosa. And I think, Jen, you and I have been worked on a case, I think it was actually Dee's case when it was at the trial, where the local authority instructed counsel for...
Yeah, they instructed Ian Wise. We phoned them up and sort of told them to instruct.
But can you just explain that process? Because this is an additional, perhaps, legal support for a child who's a looked after child that can be brought in at the sentencing phase.
Yeah, so I think so there's a concern, especially we had a concern, especially in high profile cases where and I think that happened in that case, where the press had instructed sort of QCs or them themselves to represent the press in arguing for children to be named. And without any disrespect to the criminal trial lawyers, we were worried that sort of media experts, barristers were being instructed to argue that these children should be named, and that we wanted to make sure that the defence essentially were equally armed. But there's also a separate point, and I think it comes under sort of the evidence in the guide, the idea that there's a lot of professionals whose opinions need to be put before the court for a proper decision to be made. And that includes, in a lot of situations, local authorities. And in that particular case, the local authority had duties to the children. Both children were looked after. One had been looked after for a long period of time. And I know the local authority were really concerned and actually wanted to do something. So I've been slightly flippant about us phoning them up. We ended up being in contact with the local authority, who have really wanted advice about how they could support them, and they were very concerned about what would happen. And we pointed out that given their duties to the children, them being looked after children, they were perfectly entitled to apply to the court to be allowed to make their own representations, and they chose to do that by instructing their own counsel, which was very effective. And I think that that's the first time that ever happened, but I've certainly seen subsequent cases where local authorities have taken a similar approach, either by instructing counsel themselves, maybe just putting written representations or evidence, but actually taking a much more active role in these proceedings. And while that won't happen in every case, I certainly think there are some cases where that's very useful and justified.
And I just think that that's something that practitioners should be aware of as a possibility, particularly for those in yachts or youth justice services who will be coming with a particular agenda around a PSR. If a child is a looked after child, that those representations can appear more neutral and therefore helpful to the argument that can otherwise seem quite partisan. And as Rosa pointed out, there are protections as well in the CPS guidance around this, but it tends not to be the CPS having a view in these cases. I think in Jen and my experience, it tends to be the press themselves who bring their own litigators into court to argue for anonymity to be waived. Louise, can I ask you a particular question? In your slide presentation, you put in some of those really terrifying quotes about what some adults said about children, and you said most of them have come from the internet and that you put them together to present to the court. I just wondered how that evidence has been received by the court. What has been the court's response to that evidence? Because I think probably a lot of lawyers can imagine a court could be dismissive, but could also see the worry in that. But I'm wondering whether there are any parallels with other kind of online abuse, where we see a government pushing hard for online child safety abuse legislation. Is there any value in those parallels?
And I didn't put the packs together, they were put together by the lawyers, but I was asked to examine the dossier of abuse, basically, to think about, you know, if they're linked to this, and particularly children who were still protected because they were in secure settings, they're going to come out. They're going to see this, you know, what sort of impact will they have if they're linked specifically to it? So that's why I was examining it. It is truly horrific to have to read page after page after page of that. Different views. It was accepted in the case of child A and child B that demonstrated there was a real risk to them, a real incredible risk. It was different for child G and RXG. The judge ultimately decided that there was no credible threat. This was just online, and anybody can sit and type that. It doesn't mean there's any real intent to act. I don't know whether it made a difference that child D and RXG were still in a secure setting at that stage. They weren't in the community and having to manage their own threat to themselves. They were protected very much by the prison service. I don't know if that had an impact because of where they were at the time the decision was being made. But the abuse really, I mean, there's two impacts. There's A, does this translate into a real incredible threat? And that's not my decision to make. I was more thinking about the impact reading these comments will have on the child's development, their sense of self. There's a lot of research to suggest that when children are rehabilitating, they try to develop, if they successfully rehabilitate, they develop a sense of themselves as a non-offender. We call it a non-offending pro-social identity. They want to leave all that other stuff behind. And particularly when a child's grown up, thinks, I did that when I was a child. And it's actually quite healthy for them to leave that identity behind and develop a pro-social identity for themselves that doesn't involve offending. That's much harder when they're being confronted day in, day out by abuse and reminders online of what they did as a child and how the public feel about them. So I think there are parallels around protecting children more generally from that sort of abuse. But I think these children are a specific case because it is truly horrific and there's a lot of it.
Mm. Thanks, Louise. Jen, do you think there's any kind of developing arguments given government's strong position on online abuse and safety for children?
I think it's difficult because I see the point, and I think it's probably helpful again on a case-by-case basis. What we struggle with, I think, in this area is sort of absolute. So it's very difficult to get an absolute ban on children being named. Because, you know, there's always the exception, and I think that's true in a lot of spheres. And what that means is you get, I think, quite different judgments from different judges who've just got different views on it. And so it's very difficult to get a consistent approach. So I don't know how much use that is in terms of pushing for legislative change, which some of us would want. But I do think that those sort of it's a great way of looking at it in individual cases when you're trying to persuade an individual judge to draw those sort of parallels and hopefully make more persuasive arguments about your case where that might be relevant.
Brilliant, thank you. Mike, if I could come to a question for you. You talked about looked after children being additionally vulnerable. Do you think that there, and in this child first approach, which I know there's lots of YOS and YJS professionals on the call, but there might also be lawyers who aren't so familiar with the child first approach. Do you think that there are arguments that can be developed since YJB has shifted the way you work into a child first approach that perhaps weren't available beforehand, and the additional vulnerability of looked after children.
Yeah, sorry, you were breaking up a little bit, but I think I got the thrust of the question. I mean, yes, I think that the child first approach to youth justice, I guess, has sort of, you know, changed the landscape over the last 5 to 10 years of you know, how child offending is viewed and addressed, and that starting point of seeing that child first filters through into a lot of the practice and a lot of the approaches of youth justice, which is around, you know, diversion away from the formal criminal justice system, not stigmatizing children, supporting children to develop a you know, a healthy, positive, pro-social identity as they move into adulthood. So, you know, all of those things, I guess, fit with arguments that you would make in court about why it's imperative that anonymity is granted for children. So the two things align very, very, very well. And, you know, it's a national evidence base. It's not just you know, a kind of, I don't know, it's not just a principled approach. There's an evidence base to working in that way supports rehabilitation of children and reduced offending in adulthood. So it's, you know, it's important to use the evidence as much as the principles. Thank you.
That's really, really helpful to draw our attention to that. Am I right that the evidence is based at Loughborough University? Is that right?
Yeah.
If you're able to type it into the Q&A, perhaps, so people can access that research, that would be really helpful. Yeah. We've only got a few minutes left, but Jen, I wanted to come back to the point you were kind of making about how different judges might take a different view on things. And I think we can probably say there's also been some kind of shift in the political landscape as to how children in the criminal justice system are being seen as the political environment changes in the country. And so one of the questions was that recently the Crown Court has been taking away anonymity in cases where we perhaps thought that there was we were getting more protection. We're seeing that being taken away. I know, for example, there was one in Wales recently, and that was because they'd been named locally in social media. Is there anything to prevent that, or to protect that, or to ensure that those children still aren't named?
It's been an increasing problem, social media, and I think, you know, it shouldn't really be a factor. It's actually discussed in our guide at page 5. The case of Aylesbury says just because a child's named in social media or named locally doesn't mean that they should be then named more broadly. But obviously almost everyone's now named locally or in social media, and, you know, an anonymity order actually realistically, you know, only goes so far because they are genuinely breached. So you have to, in some ways, you have to be able to get up that argument, otherwise no one will be given anonymity. I do think there's a massive difference, again, it comes down to evidence, between being named in social media and being named publicly in the press. It goes to what Louise says about pro-social identity, which is so important because, you know, you have situations also then later where you might Google yourself and it comes up forever, and you cannot get rid of that. Even the right to privacy, that's not relevant if you've, you know, been named as a defendant in criminal proceedings. Once you've got that anonymity, even if you are being named in social media, you or your lawyers can do something about that. You can then start to ask those social media posts to be taken down and start dealing with those breaches of the order. I think it's often misunderstood what the impact is. I've actually had clients who will say to me, why do I need an anonymity order? Everyone knows who I am anyway. But of course, everyone locally does. Their friends do, the people they work with do. It's a massive difference to having your name, you know, in the worst cases, put on the front page of national newspapers. And I don't think people realise that until it actually happens to them. So again, I think it's about using evidence to the court. Case law, which is in our guide, which supports that. And again, there's another case of KL recently. So there's been some good case law from the Court of Appeal recently, really emphasising that. But I think the Crown Courts, again, individual judges sometimes, you know, aren't making the best decisions. So I think it's about using that really good case law from the Court of Appeal, some of which is very recent, pointing out the case law says that this isn't relevant, and using really sort of evidence to show that there's a big difference between being named locally on social media and being named in the press, and therefore it's not good enough just to say, oh well, people know who he is, we'll name him anyway. And I think that's the best way of getting around it.
Brilliant. I think and I also, Jen, I just was thinking there was that injunction in the Supreme Court where the media had tried to name the two children or the adults involved in a case, and it had been reported, I think, in Scotland and on social media, and Lady Hale said that that didn't mean that the English press could report who the people were, and that might be something, even though it's not in the criminal context, that could be that practitioners could cross-refer to.
There's a few cases. It's not an unusual situation. I'm afraid I don't have the cases to mind, but there are a few cases where similar things have happened, where international press have put something, and obviously we can all access international press, but the English press have been restricted from reporting it. So I do think the case law is actually on side on this point. It's just that sometimes, again, you know, individual judges have their own points of view, so it just needs to be pushed and appealed. The other thing is appeal it. You know, we deal with appeals in our guide. If you have got a bad decision, you need to do it immediately, because otherwise it's pointless, or at least ask for time before the injunction's lifted for you to consider an appeal. So do look at that.
Yeah, so we're calling on, that's the end of our time. I'm really sad because I really liked the discussion, and I hope it's been really useful for all of the practitioners out there and for whom this may be an issue, and perhaps they hadn't thought that there were strong legal arguments that they needed to develop, or strong PSR, or getting experts in. So if we can help with developing that practice, please do let YJLC know. Their advice line is available to answer these and other questions. And also, of course, the guide is a great starting point for getting on top of all the legal points that you can make. So thanks so much to Jen and Rosa and Adam and Katya and Laura for that guide. We look forward to seeing you at our next webinar, which I think is going to be about sexual offences. Thank you so much for your time. We know you're really busy, so we really appreciate it. Take care, everyone. Good afternoon.